and answer session brought to you today by the Massachusetts Access to Justice Commission. My name is Jennifer Howard. I'm the Director of Legal Programs at Rosie's Place, and I am so happy to be here with you all today. It's an incredible collection of people on the call today. Please introduce yourself in the chat with your name, where you work, and one thing that you're doing this fall to manage your stress. Today's presentation is going to be recorded, and a PowerPoint will be provided to all of the participants. And probably within a couple of days, the link will be up on Mass Legal Help if you want to share it with any of your colleagues. No doubt that each of us on this call here today is here for one reason, and that's to learn how we can help our neighbors remain stably housed now that the Massachusetts eviction moratorium has ended. Each of us has a role to play, and maybe more than ever, the more we can learn to work together, the more people we can help stabilize in the face of so many layers of crisis. This looming eviction catastrophe presents unprecedented challenges, but it also presents us with unprecedented opportunity for the community helpers that are assembled here today to work together and draw on each other's skills and strengths. To set a positive intention for our time together today, I want to quote the hardworking people at the Dove Candy Factory that wrap my afternoon chocolates in wisdom. I recently opened a chocolate with this pertinent message on the wrapper. You can do anything, but you can't do everything. This is a really hard time. And as you work to take care of others, make sure that you're taking care of yourself too. Today, we're going to attempt to explain what we expect to happen now that the courts are going to be starting to see eviction cases. We're going to spend the next hour addressing the following topics: what it means that evictions can now go forward in court, what the federal CDC moratorium is and how it may help Massachusetts tenants now, how accessing the court is going to look now that the moratorium is over, but that we're still in the middle of a pandemic, how someone with limited English proficiency will be able to participate in the court process and get help doing that, and where to find legal information for resources for tenants and landlords. We hope that you will we hope to identify some key steps that you can take and help your tenants take while they're waiting for their RAFT to come through or waiting to get a call back from legal services. We're also going to spend some time today talking about accessing RAFT and financial assistance and what to expect from the governor's new expanded Massachusetts 211 program. However, this is not a detailed training on how to defend an eviction in court, nor is it an in-depth look at the governor's eviction diversion initiative or a magic guide to getting a RAFT application approved. We understand that there are lots of questions out there about how to help tenants find money that they need to pay back their rent and possibly get some rent assistance going forward. We encourage everyone to connect with their local regional housing agencies or consumer education centers, consumer education centers. We do have an excellent panel of experts here to share what they know. Please join me in welcoming the following panelists. Attorney Gordon Shaw, the Director of Client Access at Community Legal Aid, who will be moderating, thank goodness, today's panel with me. Laura Camara, the Senior Attorney with the Justice Center for the Southeast Massachusetts office. Zoe Cronin, the Managing Attorney for the Housing Unit at Greater Boston Legal Services. Iris Coloma-Gaines, the Legal Access Attorney at the Mass Law Reform Institute, and Lesley Verrilli, the Mass 211 Program Manager. I'd also like to acknowledge some behind-the-scenes support for today's program from Rochelle Hahn from the Massachusetts Law Reform Institute, Ben Golden from the Suffolk Law School, and Melanie Rush from the Massachusetts Appleseed Center for Law and Justice. Thanks to all of you who submitted questions along with your registrations for this program. We've tried really hard to incorporate those questions and answers into the presentations. As we move through the program today, please add any new questions to the chat, and we anticipate the last half hour of today's program will be used to answer remaining questions. As a reminder, again, today is going to be recorded and we will be providing the PowerPoint. With that, let's begin. And the first up is Zoe Cronin from Greater Boston Legal Services. Zoe, can you start to tell us what it means now that the moratorium is over?
All right, good morning, everyone. First of all, I just want to echo Jen's thanks for all of you and the work that you do. This is my absolute favorite presentation to give to all the people who are really out there helping in all parts of our state. It's so wonderful. Thank you. So as you've probably know and have experience from talking to people, the eviction moratorium that went into effect in April is now over. It expired on October 17th, which now means that all of the cases that were on pause during the moratorium have popped back to life. And landlords can now start new cases in housing court and district court. And I'm sure you have already experienced this, because I know that the calls are flooding into our office. So the eviction moratorium provided tons of protection. There's nothing like it that's currently in place. But there is this federal CDC moratorium that's out there. And it's a useful tool to help the people that you work with, but it's not like the state moratorium that we had. So the CDC moratorium was weaker than our state moratorium, so we weren't using it until the state moratorium expired. So now it's in full effect. At first, we hoped it might protect people from getting evicted, but that's not exactly how it works. What it does do is probably prevents people from actually getting thrown out by the constable, but it does not protect them from getting taken to court. So we'll go through this in this presentation about the CDC moratorium and how to access it and what to do, which it's really easy to call on its powers. But it's not, people shouldn't expect that if they do their CDC letter, which is the CDC declaration, they shouldn't expect that they will not be taken to court. They likely are going to be taken to court. But on the more positive note, in some of my calls with landlord attorneys, I think that they are going forward with the evictions first of the people who aren't giving a CDC moratorium letter. So if they have to pick who to go for first, they might not pick that person that did the CDC moratorium letter. So we'll get to that a little bit more. But also, there's a lot of RAFT money out there. There's 100 million now, which is good. However, the amount of back rent owed is at least 4 times the amount of money available through RAFT. So that's just an example of the scale. It's up to 1/3 of Massachusetts tenants who have not been able to pay their full rent during the moratorium and who are now facing eviction. So this is both devastating, but also something to keep in mind when negotiating with landlords. Recently, I had a case where the landlord trying to evict the tenant for paying their rent on the 15th of the month instead of the 1st, right? And in negotiating with that landlord, really, is the landlord really going to evict somebody who just pays late, but they always pay? That seems like a pre-COVID type of eviction. Maybe not something the landlord wants to pursue today. So in some ways, the fact that so few people can pay their rent does give you a little bit more negotiating power. So as you know, unemployment remains high, and the housing court is going to be running constantly now. It used to only run maybe 1 or 2 mornings per week in each session. Now the housing court is going to be running all day, every weekday. So 5 days a week from 8 in the morning until 4 p.m. And they're going to be hearing up to 3 trials per hour. So it's going to be running very full speed and differently than it was before. All right, so to talk a little bit about the CDC moratorium and who can use it. The CDC moratorium prevents eviction on any case where the tenant owes rent due to illness or income loss until December 31st, 2020. So it doesn't last that long. It only lasts until the end of 2020. There are also lawsuits going on right now to get rid of the CDC moratorium, so it could end earlier than that. But for right now, it's still in effect till December 31st, 2020. Some courts might still go forward with an eviction process, even though a tenant has filed the CDC moratorium declaration. What you can do to help is have a tenant fill out a declaration as soon as possible. And the declaration, at the end of this presentation, there's a link to where there's a good 1-pager declaration that all you do is sign and turn in. There's nothing to fill out. The tenant just needs to sign it, and fill it and give it to the landlord. That's all there is to it. There's also an online tool that's listed right here. That's that link that goes to Mass Access, and that's an online tool to fill out the CDC declaration that you can also use. And the CDC moratorium applies to you regardless of immigration status. You do not have to be a citizen in order to use the powers of the CDC moratorium. And the idea of it, once again, is just that it should keep the constable from actually evicting you before the end of the year if you've suffered any type of income loss or inability to pay rent. It doesn't have to even relate to COVID. All right, so here's who can apply for the CDC moratorium. And I think for all of us, it applies to many of the people that we work with. The income level is really high. You just have to have made less than $99,000 in the year 2020, right? And if it's a couple, less than $198,000. So it's very, very high, likely to cover everyone we're working with. You have to be unable to pay the rent due to income loss or medical bills. You have to have tried to get government assistance, which is RAFT. The government rent assistance is RAFT. So kind of partnered with the CDC moratorium, you want to next apply for RAFT, or apply for RAFT first and then do the CDC moratorium declaration. You have to be at risk of homelessness or being forced to double up with someone. And then you have to promise to make as partial payments as much as you can. But obviously, if you're working with someone who has no income or very, very low income, the amount that they could pay to their rent might be nothing, which is still okay and should not prevent someone from filling out the declaration. So how to apply for RAFT? So RAFT used to give out $4,000, and now they can give out up to $10,000. So this can really, really help people. The RAFT funding can be used to pay back rent. It can be used to pay future rent, and it can be used for first, last, and security to move to a new place. So this is really tremendous. There's two ways to apply for RAFT. You can go to the local agency that does RAFT for your area, and they're called HCECs. You can look that up in the internet. If you just Google RAFT funding and then your town, you'll be directed to the right place. In Boston, it's Metro Housing Boston. You can also call 211 and get through to RAFT that way. And I guess RAFT is going to prioritize people with court cases, but you don't have to have a court case to apply for RAFT. You can apply right away. Oh, one more thing about RAFT. You don't worry about immigration status for RAFT either. RAFT is for everybody. You can be undocumented and get RAFT.
So we have a couple questions about the CDC moratorium. Do you want me to wait till you go through what's happening in court, or is it okay to ask you them now?
Yeah, I'll answer them now. That's good.
Okay, one of the questions that came in was whether or not the CDC moratorium only applies to properties that have that are federally funded.
No, it applies to everyone. So there's CARES Act, which is another protection that only applies to federally funded properties. And that provides some additional protections for people. But no, the CDC eviction moratorium applies to every single type of rental. Could be private market, anything. Yep. And
is there any time limit for when a tenant has to do the declaration and give it to the landlord before it can be, like, does it expire at some point? Or is there
no, it does. I mean, I think at some point it would be too late, right? Mm-hmm. But it prevents the landlord from taking each next new step. So I always try to, what we did right before when we could tell the eviction moratorium was going to be lifted, we called all our clients and had them fill out the declarations because it's so easy and so quick to do. But it's not too late if someone already got the notice to quit. It's not too late if someone already got the summons and complaint. It's not too late if they're in court, because the real power behind the CDC moratorium is to keep the constable from kicking you out, right? So I think as long as you did it before the constable was coming, it would still have some power, but some of those are decisions the court would have to make about what they're going to do about it. Before the landlord goes to court, they actually have to sign an affidavit that they did not get one. So ideally, it would be that the landlord would get it before they went to court, because the judges do want to see, hey, did you get a CDC eviction declaration, a moratorium declaration? The judges want to know if that was the case. And then the judges want to know why you're still going forwards, even if you did get one. And I think the judges may have some slight differences of opinion on how they apply that. So I think ideally, it's such a quick, easy form. All the person has to do is sign their name to it. I would just do it for everyone right away. The more grief you can spare people, obviously, the better.
There is another interesting question, and that is, what are the legal consequences for signing the declaration if you might not actually meet the criteria?
You should not sign it if you do not meet the criteria. That would not be good. But most people, not most, there's a ton of people who do. But if you're talking to someone and they don't owe any rent, right? And they're getting evicted for another reason that doesn't have anything to do with rent and they don't owe any, then don't do the declaration for that person, right? Or if you're talking to someone and they're a single and they make $120,000 a year, then they're over that income limit that's protected. So don't do it for that person, right?
In terms of the order of which jobs to get done first, is it okay to sign and submit the declaration and then begin your RAFT application after you've already signed it?
Yeah, I mean, I do them, if you're doing them on the same day, I think that's fine, right? Ideally, in the perfect world, the RAFT would come first and then the declaration, because on the declaration, you're saying you already applied for RAFT. But I think if you're working with someone and in the same session, you're doing both, that's fine.
Okay. There are another couple of questions for general eligibility. You talked, I think, a little bit about this, but could you say a little bit more about how the protection might apply to people who are on a fixed income, so maybe did not have any particular loss of income during this time, but still haven't been able to pay their rent?
Sure, yeah, that was an interesting question that came in early, I remember it. We talked about it in our group. I think, remember, you can call on the CDC declaration for two reasons. One is you lost income, which doesn't apply in this situation. But the other is that you have increased medical bills. And so likely if someone's on a fixed income, but what they have to spend on rent has been reduced, they should take a look if that's medical bills. For instance, we were talking about, well, what if you've had to buy masks and cleaning supplies that you normally would not have because of the pandemic? And that's the reason that you're having trouble paying your rent. That could be one reason. If you're having to pay for delivery of medical, like medicine and things like that, that you didn't have to pay for before, and that's what's putting you over, that could be it. So I think I would really look at why someone's expenses have increased so that they can't pay their rent, if that's the reason why, and to see if that is related to anything medical, and look at it that way.
Thanks. How about if the tenant is a squatter? So it's somebody that is a holdover guest from a prior resident that's no longer there. So they're the only ones in the apartment, but don't necessarily have a lease or anything like that. Are they eligible to get the CDC moratorium?
Probably
protection?
not, because they're not a tenant.
Okay.
But you should, I mean, it's worth trying. All those are unanswered questions by the courts, but my guess would be that it applies to tenants, not to people the landlord never knew were there.
And I would just add, though, that the question of whether somebody is a tenant is a really factually dependent question.
Yeah, true.
And so I think back to what Zoe said, if you're somebody that you're living in an apartment and you've paid money to somebody at some point, then you certainly should assert your rights under the CDC order if you can sign the declaration truthfully, and then it's going to be a question for the court whether or not you're a tenant.
So following up on that, Laura, there's a question, what if a tenant is a tenant at will? Can you just expand on what you were saying a little bit?
Yeah, that's a tenant at will is a real tenant. Yeah.
Can you maybe just lay out exactly what you mean by tenant at will, or what we use when we use that term?
I'll take that. So a tenant at will is a tenant who has created their tenancy by paying rent rather than by executing a written rental agreement for a set term. I think what that question also was probably going to was whether or not the CDC order is going to cover no fault evictions. And that at this point, what the courts are saying is that they are only going to apply the CDC order to cases where there is a claim for non-payment.
But I think you could at least say claim for money owed.
Right. And that's exactly what I was going to say. Yeah. So I think if there's any claim for money owed in the case at all, and even if the landlord isn't raising it, I would encourage tenants to still provide the CDC declaration and still raise that to the court, because I think that is an open question.
Okay. Is that it on the questions about the CDC? I know I saw one that I'll just answer really quickly. No, the CDC eviction moratorium does not apply to commercial tenancies. All right. Okay. So
Thanks, Zoe.
Okay, moving on to housing court reopening. So the housing courts are open and they have been scheduling the cases that were on pause. And there's a whole lot of these coming in. There's a whole lot of landlords requesting execution, which means a whole lot of landlords requesting the power to have the constable come and throw tenants out. And those are coming through pretty fast and furious. If a tenant gets something like that, they should definitely call legal aid. And there'll be information about that at the end. Right now, all the hearings are on Zoom pretty much. I know that might not be true in Central Mass, but in Eastern Massachusetts, all of the hearings are by Zoom, which can be a real challenge for some of the people we work with. People can also participate by telephone, but they have to let the court know ahead of time. There's been a little bit of a change with answers. Answers, discovery, and jury requests are due 3 days before the first court date. The summons and complaint does not list when you have court. That comes in a separate letter. So the whole process is different from what people were familiar with before the eviction moratorium.
So I would just add there as well that when tenants get the notice of the hearing date, following receipt of their summons, it will also contain a resource page from the court. They should pay attention to that. It's going to provide information on how to access RAFT, how to access legal services, how to access other resources that may be available. And so tenants should definitely pay attention to that. And also, if they are concerned that they're going to have difficulty accessing Zoom, be it technology needs, disability related needs, then they should call the court as soon as they get the notice and let the court know. The court is under an obligation to make sure that everyone can access their hearing. And so if somebody is going to have difficulty, they need to immediately call the court and let the court know. If they don't have the ability to call, they can physically go to most of the courthouses at this point are open. In the different divisions, there may only be one office that's open. So for example, in the Southeast Housing Court, only the Fall River and New Bedford courthouses are open. But they should physically go to the clerk's office and let the clerks know that they don't have phone or internet access to access their hearing.
So also, if you have someone you're working with who gets a summons and complaint for court, you should have them call legal aid, right? Because we are helping people do their answer, discovery, and jury demand. And we are having more lawyers coming online to help people. It still won't be enough to help everyone, but we will have more resources than we've had before. So if someone does get court papers, have them call legal aid. In addition, I'm going to go through briefly later some things you can do if you cannot get through to legal aid, because it is definitely possible that despite their best efforts, it cannot get through. And I don't want people to get to have people have a bad experience and not protect themselves if they just can't get through. So I'll also provide that information. So yeah, every first court date is a mediation. It's a status conference and then it goes to a mediation. So that's a chance in a Zoom room to sit down with the opposing side and also with a mediator to try to work out a deal. It's important that people not work out deals that don't work for them, because you're going to be held to it. Most people don't get evicted by the judge. Most people get evicted when they sign a deal they can't keep. So some things to think about. It can take a long time to get RAFT, right? I think the court is expecting that RAFT will take 2 to 6 weeks to get, but reality, due to the huge demand, it could take up to 5 months to get RAFT. So that's just something to keep in mind. So you wouldn't want to have someone signing an agreement that they're going to get RAFT in 2 to 6 weeks, because they will not be able to guarantee that. It could take a really, really long time to get RAFT due to the overwhelming demand. Another thing is, a person might not want to sign up for what's called an agreement for judgment, which means if they cannot keep the agreement, that they will get evicted. Someone might sign up for a payment plan with the best of intentions, but due to the uncertainty of everything right now, nobody knows if we're going to go into another lockdown and the jobs will be put on pause again. Nobody knows if people are going to lose their jobs. Signing up for a payment plan where the penalty is you get evicted is a really bad idea, and something I would really warn people against. Again, most people don't get evicted by the judge. Most people get evicted by signing an agreement they cannot keep. So then the thing is that if things don't work out, so also at mediation, if they don't have a lawyer yet and they want a lawyer, they should ask the mediator for an attorney of the day. And they should say, I would like an attorney of the day to be in the mediation, or at a minimum, I would like the attorney of the day to take a look at this agreement and give me some advice on it. Because if you're thinking about reaching an agreement, that's a very serious thing that could have big consequences for your tenancy. Then if you don't do a jury demand, your next court date will be the trial. The trial might be very rapid. The court is estimating the trials will be 15 to 20 minutes long, which is an extremely short trial. A normal trial would be longer, would probably be about an hour. A trial with a lawyer would probably be 2 days. So 15, 20-minute trial is a very short trial due to the amount of volume. What's the alternative to an agreement for judgment? The alternative to an agreement for judgment is just an agreement, but not one that results in your getting evicted. So I promise that I will pay by RAFT if I get it, and we can come back to court in 6 weeks and see if I got RAFT. But if I didn't get RAFT through no fault of my own, because I did all the steps and the landlord did all the steps, but all of the delay is just due to the volume of people trying to move through RAFT, then I don't get evicted. Instead, we get another court date, another 6 weeks out or something, to check in about how things are going, right? All right. So another thing to watch out for is, because of the backlog that will be in the courts, please expect landlord attorneys and larger landlords to approach tenants outside of court. Larger landlords are calling the tenants to see if they can work something out outside of court, which is legal, but which is dangerous, right? Because people might reach an agreement that is legally binding outside of court and not realize that that's what they signed up for. They might sign something that's an agreement for judgment that gets filed in court that could result in their eviction, and they might not realize that was what it was that they were signing. They might have thought they were signing a work things out agreement. So another thing that you could do is just caution people that when they're signing something, if it's got a court document heading on it, it could be an agreement for judgment that's filed in court.
Zoe, can we pause for a second, and could you just say whether or not that two-tier process that you're talking about applies to all evictions, all types of evictions that are going through the housing courts and the other courts, or is it just for non-payment cases?
All types.
I would just add too, for those who have cases in the district court, that first event is not going to be a mediation, because in most cases, because the district court does not have housing specialists who conduct mediation. It will be a discussion though between the parties if they're interested in settlement, is my understanding from the district court. So the district court, it's going to be a little bit different. District court is going to be asking the parties whether they're interested in settlement, and then maybe referring them to outside mediation services.
Does anybody have any idea how much notice the courts are going to be giving tenants in terms of how far in advance of their first court event will they be knowing what day it's going to be?
The court has told us that it's going to be at least 7 days. That said, I have already had hearings in which I had less than that, less notice than 7 days. So I think people should be prepared for short notice periods. That said, also though, as the court starts getting more and more cases in, I think things are going to get more and more backed up. So they may get more notice, but it is possible that it's going to be short turnarounds.
Yeah, we've definitely had cases already. Like I have a case that's on Thursday and I got notice of it on last Friday. So just a little under a week.
And Laura, I think you answered this in the chat box, but maybe just to make sure that everybody saw it. If somebody does not have a computer, does not have a phone or access to be able to participate remotely, what should they do?
So they need to notify the court of that fact as soon as possible. So that may mean physically going to the courthouse and letting the clerks know, walking in and letting the clerks know that way. If they can borrow a phone to call and let the court know, the court has an affirmative obligation to make sure that people have the ability to access the hearing. And so the court may need to provide that person access to a computer to attend a Zoom hearing, may need to provide that person access to a phone, or may need to schedule the hearing in person to accommodate that need.
I just want to add to that the court is working on doing what's called Zoom rooms. I think they're going to go in Chelsea and Brockton so that if folks don't have the ability to computer or the phone, they can actually request to go to the Zoom room, and there'll be a computer there. If they need an interpreter, the interpreter will be available by phone. So that's a possibility, but you would need to ask specifically if the Zoom rooms are available, because they, I'm sure they're going to be filled up.
All right, so I guess next page. All right, so then one last thing I'm going to talk about is the answer discovery and jury demand. So when somebody gets court papers, the papers that say they're actually going to go to court, that's called a summons and complaint. And at that point, someone should definitely fill out the answer discovery and jury demand. This is super, super, super important. A person should not go to court without filling out their answer discovery and jury demand. It's the most important thing a tenant can do to protect themselves. First of all, it allows the tenant to say things about their side of the case. Let's say the landlord says, tenant, you owe rent, but maybe the landlord hasn't handled the security deposit properly. That could mean that instead of the tenant owing the landlord $1,500 in back rent, the landlord actually owes the tenant $4,500 in mishandling the security deposit. And it could mean that the tenant wins and gets paid $3,000, right? So they're very, very important things to bring up in the answer, discovery, and jury demand. We would also advise people to choose jury demand so that they have their case decided by a jury, which is their constitutional right, and also protects them from having to go in front of the judge for a 15-minute trial on very short notice, right? Legal aid is doing answer, discovery, and jury demand for as many people as we can, all day, every day, at night included. However, there's if you're finding that folks cannot get through the line to get to legal aid, which in seeing how backed up the courts are going to get, and in seeing how backed up RAFT is, we can only imagine that legal aid, despite having additional resources, could get backed up. And we don't want to be the bottleneck if someone cannot get through. So if you cannot get through to legal aid, a person should do the answer, discovery, and jury demand on their own. And we have a really easy online form to do the answer, discovery, and jury demand. And that's listed in the gray box on this slide, www.gbls.org/made. That's an online tool that a person does not need any legal knowledge to use. It's just based on their own life experience. It asks common language things about what happened to you. Like, did you pay a security deposit? Yes, no. You know, did the landlord ever give you a receipt for it showing it was put in a separate bank account? Yes, no, right? So it leads someone through the whole answer, discovery, and jury demand process very easily and creates all the forms that you need. There's also a printable version that's listed next, at Mass Legal Help printable forms. So we are encouraging people to call legal aid if they're at the stage they need to file the answer, discovery, and jury demand. But if you can't get through, do it on your own. It is better to turn in an answer, discovery, and jury demand that you did on your own than to skip it if you couldn't get an attorney. And it will also help if the point that the attorney meets you is in court. Because if you don't get an attorney, but you do end up getting an attorney once you're in mediation, but you did file the answer, discovery, and jury demand, that helps that attorney, the attorney of the day, do a much better job in your case because you have asserted your rights beforehand. So that's really, really good.
Zoe, can litigants still transfer their cases from district court to housing court automatically?
Yes, they can. Yep, absolutely.
Should they do that?
It depends. You have to make a decision about what you know about the courts. Traditionally, the housing court is really, they're experts on housing law, right? So you'll get judges that are experts in housing law instead of judges that are generalists. But the district court might be a little bit more tenant friendly right now. It also depends who's the judge in your district court, who's the judge in your housing court. Those are sort of specialty things. But you would have more access to lawyers if you transfer to housing court because the new COVID eviction legal help team that's bringing in additional lawyers to help tenants, they will be working out of the housing courts. So that is an additional reason to transfer to housing court, but both district court and housing court can be a good choice. It just depends.
And right now that the housing court's interpretation of the CDC order is that they are going to allow cases to proceed through to the execution, meaning they're going to stop short of issuing the execution. The district court currently is stating that any case in which a tenant has provided a CDC declaration and there is a claim for non-payment, they are going to stay. So that may be a consideration for someone in whether or not they're going to transfer their case from the district court. But it really is a case-by-case analysis.
Yeah, the district court is using the CDC moratorium much more strictly, which is good for tenants. All right. So Laura, is this the part where you take over? I forget.
Sure. So Zoe already mentioned, some of these issues, but we just really wanted to highlight that particularly in the housing court, the court is really going to be encouraging people to resolve their cases in mediation. And for some people, that is the right decision. But it may not always be the right decision, and people should not feel pressured to sign an agreement that they are not comfortable with. So the first date in housing court will be a meeting with a housing specialist, a mediator, and the landlord and tenant to try and resolve the case. If anybody is in that mediation session and they have not yet talked to a lawyer and they wish to, they can ask to speak with the attorney of the day or lawyer of the day. There may not be a lawyer for the day available right at that moment, but they can ask the court to not proceed with the mediation so that they can have the opportunity to speak with the attorney for the day. You cannot be forced to sign an agreement against your wishes, and you cannot be forced to sign an agreement if you want to talk to a lawyer first. So anybody who wishes to do that can still do that. And as Zoe said, there may be delays in accessing legal services. And so it is possible that someone will be at this point and will not yet have an opportunity to speak with a lawyer. So they can absolutely ask to speak with a lawyer for the day. And there's also going to be lawyer for the day available for landlords. So if a landlord is unrepresented and they wish to speak with lawyer for the day, they can also do so. they can also ask the court for that opportunity. So again, no one should sign an agreement that they are not comfortable with. If you do not believe that you can comply with a payment agreement that is being proposed, you should not sign that. All that's going to end up happening, if it's an agreement for judgment, is if you miss a payment, then your landlord will be able to move you out. So it's very, very important to only sign an agreement that you actually can comply with. Similarly, if what's being proposed is an agreement for you to move out and you don't have anywhere to go, then that may not be the right choice for you, and you should ask to speak with a lawyer before doing that. Additionally, as Zoe said, there is a lot of RAFT money available, but there may be delays. And so you need to be aware of that, and don't sign an agreement saying you're going to be paying all of the money back in 4 weeks, assuming you're going to get RAFT if you haven't even applied yet. So you need to make sure that you're not agreeing to timelines that aren't realistic, and the landlords need to be aware of that, and need to realize that this is not going to be an immediate turnaround. RAFT is flooded already with applications, and so we just need to all be aware that there are going to be delays and that agreements need to account for that. Additionally, as Zoe highlighted, the RAFT money that was allocated is not sufficient. We're anticipating it's a quarter of the need, and that was a quarter of the need at the time it was allocated. That need is continuing to rise. And so negotiating for reductions in what is owed is going to need to happen. Additionally, tenants may have legal claims that will result in reductions of the rent. And so they should not be signing those away without talking to an attorney or without getting some compensation for that in the form of a reduction of the rent. Additionally, individuals with disabilities may have additional rights under state and federal anti-discrimination laws. And so those may need to be considered in entering into an agreement. Also, I would just like to flag that litigants with disabilities who are not able to represent themselves, either because they don't understand the proceedings or aren't capable of fully participating in those proceedings, may be entitled to have a lawyer or a guardian ad litem appointed for them. So if you're working with a client that you really believe is not going to be able to understand the proceedings, that needs to be communicated to the court as early as possible. Next slide. And maybe before Iris is up on language access, Jen, are there any other questions about the court process?
There was a question that I think that you might have answered on the chat, but just again, to make sure everybody caught it. Can you talk a little bit about what the court service centers are able to do right now in terms of helping people with document preparation?
The court service centers are still operating fully remotely, and based on the conversations that I've had, that is likely to continue for quite some time. So they have Zoom rooms available, they're accessible by phone, and they are assisting litigants in all types of areas and matters, but it is going to be remote. So if somebody needs assistance with an answer in discovery, certainly they can call the court service centers, but we would really encourage people to first try the MAID system, gbls.org/MAID, because we really think that is going to be the most accessible way for most people. If people are not tech savvy, they don't feel comfortable using their computer, then we would encourage you all, if you're able to get your clients, your consumers, physical answer and discoveries by printing them off of masslegalhelp.org. Those are forms that were designed for litigants to fill out on their own, and they do a good job of preserving litigants, tenants' defenses and counterclaims. The answer form that the court has available and that I think some of the court service centers use does not do as good a job of flagging for tenants potential claims and defenses and making sure that those are claimed. Additionally, the courts form does not have a jury claim listed on it. And as Zoe said, that is a constitutional right that tenants have, a right to a trial in an eviction case by a jury. And I would be very concerned about any tenant waiving a constitutional right without talking to a lawyer. So I really would encourage tenants, unless they have spoken with a lawyer, to assert that right. And then if they wish to waive it later, they can do that, after having spoken with a lawyer. But that is a really important tool. And that is also available through the MAID system, as well as through the forums on Mass Legal Help.
Laura, just a couple of questions. Can you talk about what happens if somebody does not show up for one of these court events?
So the first tier event in both district court and housing court, and by that first tier event, I'm referring to the status conference or the mediation. The courts have stated in their standing orders that individuals will not be defaulted for missing that date, meaning a judgment won't enter against them for missing that date. However, in the district court has stated that if an individual misses that first date, they will have to ask for leave of court, meaning they'll have to file a motion to request the right to file a discovery request. So they could lose that right by not attending the first date. If an individual, however, does not attend the second date, the scheduled trial date, they could be defaulted, and meaning a judgment could enter against them without them ever being heard by a judge or ever presenting their case.
The other question I think would be important for this particular audience is there a role for advocates to play in the court process right now?
There absolutely is. So as Zoe highlighted, a couple of things. One, making sure that anybody who believes they are eligible is filling out a CDC declaration and giving it to their landlord. Two, making sure that everybody who has received a summons and complaint is filing an answer, discovery, and jury demand. As Zoe said, there's a good chance that legal aid is going to be backed up. And so tenants need to get those need to get those filed. And then if a lawyer is able to assist them later on, it's quite easy for us to amend that answer if we need to. It's much harder for us to affirmatively file an answer late. That the court is much more likely to deny that request. So it's really, really important that advocates are encouraging their clients to file the answer, discovery, and jury demand timely, and referring them to the resources like MAID to do that. Additionally, if you have clients that do have disability needs or technology needs, making sure that they're notifying the court of that very early on as possible. Those are all things that I think advocates can really be doing right now to assist their clients who are in this process. And then also, getting people to the RAFT programs to apply for rental assistance if they need it.
Do you know many non-lawyer advocates go with tenants to court for support reasons? Is there a way that you know of yet where a tenant could say, let the court know that they wanted to bring an advocate with them on a virtual hearing? Yeah,
they absolutely can do that. I would say letting the court know ahead of time is better, because the court may not let somebody into a Zoom room unless they affirmatively know who that is. In mediation settings, it's a little bit, the landlord, the other side potentially could say that they don't want somebody else in the mediation, but typically if it is an advocate who's there for support, the court will allow that person in. But letting the court know ahead of time is always the best policy.
Thank you.
I did notice one thing in the chat. Somebody did post that the court service centers are using MAID. So in my experience, that isn't universal. That may have changed, but that was not the case prior to closures. Some of the court service centers were still using both the Mass Legal Help answer and the court's form answer. So if that's changed, that's great. But just be aware that they may not all be using MAID, or at least we're not all. prior to the closures.
Great. Thank you, Laura. And Zoe, I know that there's a lot of questions in the chat right now on accessing interpreters. So luckily, Iris is here to talk us through that. Thank you.
Good morning, everyone. Thanks for being here. We're all trying to do this work together for the many, many people that are affected here in our state. So, and as Jen pointed out early on, we can do something, but not everything, right? So, so I want to start by saying that any limited English proficient person, oops, I don't know how I did that. Any limited English proficient person has the right to a free interpreter in court, as well as at DHCD, which is the program that runs the Emergency Assistance Shelter program here in Massachusetts, which may come into play for your clients. If they do end up getting evicted, they can apply for shelter, and I'll talk about that in a moment. But for all courts, there is a helpline, and I have the number here on the slide. It's 1-833-91-COURT. This line is available only in English, Spanish, and Portuguese, unfortunately. The court is working on getting more languages on the helpline, but for now it's only available in English, Spanish, and Portuguese. If your client speaks a language other than Spanish or Portuguese, then you can request an interpreter by calling the clerk's office of where the notice came from. The phone number likely will not be on the notice, so you'd have to Google the name of the court and then call the court and let them know that the person is limited English proficient and they need an interpreter in whatever language. That is the best time to request an interpreter, as soon as the tenant receives the notice. However, if that didn't happen, then anytime, the interpreter can be requested at any time. Preferably and optimally, it's at the beginning of the case. But if somehow the tenant was able to make it to the Zoom hearing and needs an interpreter, the tenant can also say at that point, you know, I need an interpreter, and they would reschedule the hearing in order to accommodate that. Something I also want to say about in a mediation session, as Laura mentioned, all cases pretty much are going to be going to mediation first, and in district court a discussion. So, but with regard to the mediation in housing court, there is an actual housing specialist who also can be called a mediator. Several of them do speak Spanish and Portuguese and other languages. The tenant should really be asking for an interpreter, even if the mediator speaks their own language, because it's really a conflict. The mediator is not there to represent the tenant, and the mediator is not there to represent the landlord. The mediator has a role to be mediating, to trying to get some kind of a settlement between both of the parties. And as friendly as the mediator may be, and as much as the limited English proficient may feel comfortable with the mediator because they speak Spanish or they speak their own language, the limited English proficient person really, really needs to ask for an interpreter. And the court, for the most part, agrees that this is a conflict, but we've seen it happen. So you want to make sure that your client insists on that, because it is not appropriate for the mediator to also be interpreting, because the mediator is several reasons. One, the mediator is not trained to be an interpreter 99% of the time. And number two, because they're not trained to be an interpreter, they may not necessarily interpret what the landlord is saying in English to the tenant. So it's really important to do that. So if your client needs to apply for emergency assistance shelter, then I just want to let you know that they are also eligible. They also have the right to get a free interpreter. And that goes for the time of application at the main office, at the field offices, in hearings and at all the shelters. And that there was a settlement made between our office and the Mirror Coalition with DHCD with regard to language access. And under the settlement, it also applies to people who are applying to home base in the EA shelter system. And home base is basically a certain amount of money to move into an apartment after the person has been in shelter for some time. But the interpreters are available. The interpreters are have to be available to folks the entire process at the intake. Each family that goes should be asked which language they prefer to communicate in, and if they're not asked, they should, you know, make it clear what language they prefer to communicate in. They also are given a one-page sheet with language access information about their right to an interpreter, a free interpreter, and that the interpreter should be available from beginning to even at the time that you're living in the shelter. And so under the settlement agreement, oral interpretation is available for everyone. It has to be available for everyone. And if you need an interpreter, you should be calling this number, the 617-573-1106, and press 0, and you will get a person, and the limited English proficient person should be identifying what their language is, and that way they can get somebody on the phone to interpret. Friends and families can't be asked to interpret. It can only really happen in emergency situations. And the staff at the shelters and DHCD can interpret, but only if they're fluent in the family's language. This is not true in hearings. In hearings, there has to be a trained interpreter. So written translation is a little bit different than oral interpretation. Everyone's entitled under the law to oral interpretation, but for written translation, it's available to the most prevalent languages in the region at the time. And these happen to be those languages. And so the DHCD has to provide vital documents in these languages in writing. However, not all of it's only the standardized portions that are in writing, not necessarily the portions that are specific to the tenant. But every family has the right to have the untranslated portions of those documents orally read to them in their primary language by DHCD. If you have any problems with regard to language access at DHCD, they have a language access coordinator whose email is up on the screen. You can file a formal complaint there. But if you have any language access problems whatsoever, whether it be in court or at DHCD, please feel free to email me. I'm the language access attorney at MLRI, and I will do everything I can to help you, you or your client get the interpretation they need in court or at DHCD. I don't know if there's any questions that came in, Jen. I wasn't really looking at the chat.
There is actually, Iris, do you have any knowledge about what the court can do to accommodate folks who are visually or hearing impaired?
They do have to accommodate folks that are visually and hearing impaired, and they should be asking for those. As far as the deaf or hard of hearing, they need to let the court know, just like as for an interpreter of a language, they need to let the court know ahead of time. The deaf and or hard of hearing interpreters are very much harder to come by and are less available than the interpreters for languages. So they should be contacting the court as soon as they get their notice, and their hearing might even have to be postponed, but they should not be having the hearing without a sign language interpreter for sure.
And do the language access rights that you just went through, do those also apply to folks who are applying for RAFT?
They should, because I believe 211 it's a state. I don't know if it gets state funding or federal funding. Yes, which I believe it does. So if they do receive that funding, those would apply to the RAFT applications also.
Those are the questions related to language access that I've seen, but I will keep looking through, so in case there's any that that we need to circle back around to at the end.
Great.
Thank you, though.
Thanks, Jen.
So we already kind of talked about this, Jen, but just we wanted to once again flag kind of the key steps that all tenants should be taking and all advocates should be, considering when advising their clients about what to do or what they should be doing to assist. So anyone who's behind on their rent should be applying for rental assistance. Anyone who is behind on their rent should be reviewing the CDC declaration, and if they believe they are eligible, filling that out and giving it to their landlord. Any tenant who has received a summons and complaint telling them that a case will be filed against them should be filing an answer, discovery, and jury demand, and utilizing the MAID system, contacting legal aid for help, utilizing the mass legal help forms to get that answer, discovery, and jury demand filed. We're encouraging people to apply to legal aid, and Gordon's going to be shortly talking about some resources to assist in finding the correct legal aid office. If a tenant has gotten to mediation and they do not have a lawyer, they should not be signing anything that they aren't comfortable with, and they should feel empowered to ask for a continuance, to ask to speak with a lawyer. And any litigant who is limited English proficient should be requesting an interpreter from the court as early as possible. And I would just flag, that people should really consider the fact that being comfortable speaking in English in a normal conversational setting is not the same as being in a court hearing. I have many, many clients who are quite comfortable conversing with me in English, even though it's not their first language. But when we get into court, it's a much, much different thing. The legalese is hard enough to understand. But being in that setting, the stress of it, and the importance of clear communication, I really, really would encourage anybody that English is not their first language, certainly be empowered to ask for an interpreter and consider the fact that communication in a court setting is just not the same as speaking to somebody, about a basic conversation. And then additionally, anyone with a disability should request an accommodation from the court as early as possible. And that accommodation could be any number of things. Could be having an in-person hearing instead of a Zoom hearing. It could be having an advocate with you. It could be, having an interpreter if you're deaf or hard of hearing. So those accommodations should be requested as early as possible.
Thanks, Laura. I believe is the next section up for a chance for us to learn more about the governor's new expanded Massachusetts 211. And I believe that Lesley Verrilli is here on the call. Lesley, are you available to speak to us now?
Okay, can you hear me?
Yes.
Yes.
Thanks, Lesley.
Having me do it at first. Okay. Okay, so first of all, thank you for allowing me to present kind of Mass 211's role in the situation that we're finding ourselves in right now regarding housing. Mass 211, what our traditional role is, and what it's always been, is to help connect callers to information and referral services for health and human services and community resources. So what that means is that when a caller contacts Mass 211, they can expect to be provided with information on RAFT IRMA, and if appropriate to the situation, legal services, information on the moratorium. A lot of callers are not aware that of certain parts of the situation, like for example, that that they may not have to leave right away. A lot of individuals see, for example, a 14-day notice and think that the 14 days means that they have to be out at the 14 days and will actually voluntarily leave the residence. Situations like that occur often. So when individuals call us, we kind of listen to their situation in a very scripted manner and help them determine what part of the process they're in and which services would be best able to assist them in the next step for them. So that could be an individual calling who's already homeless, trying to get back into housing, or somebody who's in a situation where they've received an eviction letter for non-payment of rent. We're also getting a lot of callers who have started receiving eviction letters for other reasons. Unrelated to that, callers who had previously had been in the eviction process pre-COVID, whose landlords have kind of taken up the mantle. So we're kind of trying to help callers navigate through the process and determine which services might be the most beneficial to them. In the course of that, there's other components involved, including things like emotional support. Right now, because COVID's happened and individuals are not able to leave their house, there's a lot of services that have shut down in general, things as simple as like the movie theater, you can't visit your friends. So individuals who may have already been in an at-risk situation in terms of isolation before are feeling that even more. We do offer an emotional component. So anybody calling our service can get access to Call to Talk, which is emotional support suicide prevention lifeline. We also are working in conjunction with Riverside Community Care to offer a program called Mass Support, which kind of offers access to a licensed therapist that would help somebody kind of work out a game plan for obtaining emotional supports going forward. We also are working with the Department of Early Education and Care. With the state, we help with the state's subsidized waiting list for childcare, and parents who are currently homeless are getting priority for childcare assistance. So parents who are homeless, partially because they don't have have lack of access to income, can get assistance with childcare right away by calling us. We can get them on the wait list and expedite their application up the system so that they can hopefully get access to childcare more quickly. Hopefully stabilizing their income would allow them to kind of mitigate their housing situation and help them get back on track. We do also have access to the waiting list for other parents. A lot of parents are behind on rent right now in general because of lack of childcare. The childcare wait list does have income requirements, but at the same time, we do have access to childcare provider referrals. Parents can reach out to all of the options for child daycare options in the area and see if there's any options that may be offering grants, signing fees, discounts, or scholarships. That can be a significant support service. In addition, like I said, to helping callers identify where to apply for the RAFT program and try to get that part of the housing situation dealt with as well. If a household is becoming homeless, we would connect them to the Department of Housing and Community Development hotline. If they've already been through that process, we're going to help them connect them to secondary services, so community rooms and or homeless advocacy groups. Maybe other support services, like maybe they are not necessarily imminently homeless. Maybe that could be something that happens in the future. Maybe they have access to regular income. So maybe that caller would be better benefited by first-time homebuyer program. So there's a lot more assessment that happens, and it happens outside of just the topic of RAFT, IRMA / direct legal assistance, because we help deal with the component of the household situation that is unrelated to housing as well. So help with cell phones. I had somebody that called the other day that one of the main barriers that they had to access to services, but they didn't have access to a phone. So helping people get access to a phone in that circumstance. So it's a little bit more of a wraparound service, and it has a lot more to do with helping connect them to other services as well, like childcare, education training, transportation, employment, emergency shelters, disaster services, mental health and crisis assistance, and other sorts of financial supports. If the caller doesn't have access to a computer, we can try to help them connect with community agencies in the area that might offer assistance with benefits, applying for benefits, things like that. So it's really a little bit more of a comprehensive service to do with general information for housing resources, but also helping connect them to other support services that are going to help them kind of stabilize the rest of their housing situation.
Lesley, that's wonderful. And I just wanted to say out loud that I honor the fact that you are probably spending a lot of time on each one of these calls, especially if you're covering such a wide area. And I'm sure that absolutely everybody on this call right now can appreciate the feeling of being the receptacle for people's angst. And that's not an easy job. Can you just tell us, remind us, is 211 available 24 hours a day? And what does the process look like when somebody calls? Are they always getting a live person?
You will always be able to reach somebody here. We have a rolling call system. We don't skip over calls. If somebody ever called us and thought that they hadn't gotten a call back for any reason, if they called back in the next day, they would be in the queue again and would get a call. So generally people aren't skipped. Right now, there is a little bit of a delay in reaching a call representative. We're only in this maybe going on the second, almost third week of having the moratorium lifted, and individuals are starting to get their notices in the mail. So we are getting a lot of calls from people who see that sign on the interstate, who have recently got those letters, who have that on the top of their head. And we do spend a lot of time with each caller, and we are in the process of hiring. So they may experience a delay in getting a call back, but when a representative calls them back, they will spend some time actually talking to them. Generally, it's not going to be more than a day or two at the very most. Most callers get called back the same day.
Are there certain hours of the day that somebody might expect to get called back? I think many of us have heard stories of folks getting called back very late in the night or early in the morning. Is that something that's happening?
We do have a rolling call system, and there's no way for me to shut off somebody's call. So if they did call during a time of the day when it was busy, it is possible they could get a call back at night. Most people just call back the next morning. We haven't actually had anybody really that is too upset about it. They're more able to get access to somebody in general, and that we're expecting that to kind of be mitigated and kind of go down over the next couple of weeks as we're hiring. It's more of an initial kind of push of, we just started this a couple of weeks ago. It's more of an unexpected initial push of calls at this point than anything.
Can you tell us, are interpreters available for folks with limited English proficiency?
I'm working on a different routing system right now, but right now we have our menu available in English and Spanish. The only menu option on the whole menu that won't go through if you don't select an option would be the first one for language. So somebody has to select either 4 or 8 for either English or Spanish. So if somebody speaks another language, you can kind of coach them to try to get one of those numbers. But as long as they're able to get past that part of the menu, they can just listen until someone kind of picks up the phone. I'm working on an alternative path for them to be able to take with it, an alternative number that makes it so they skip the queue, so that there's not, because there's no way that they would be able to listen to and understand a message offering them a callback, right? So we're in the process of working on making that easier. But right now, if somebody can make it through our menu and reach a representative, we work with over 100, and we have an interpreter services that has over 140 or 150 languages that we offer. But trying to find a way to make it so that every type of language that could possibly hit our system would be serviced by the menu when you first call in is just logistically not possible. If you just saying those languages in their language would take like 3 minutes.
So I'm sorry, can you just repeat again then? What is the tip that we should be telling people if they do not speak English or
If they don't
Spanish?
speak English, when they call in, I would just ask them to hit. I would ask them to hit menu option 4 when they first call in. After they hit, if they speak anything other than Portuguese, Spanish, or English, you can tell them to use the runaway extension, which is one for a little while. It'll get them through a little quicker. Like if you have somebody that literally wouldn't be able to make it through any part of a menu to be able to reach somebody. I really don't want to not service anybody while we're trying to figure out a better method for people to communicate with us. Generally, somebody that doesn't speak any English might have a caseworker or a manager reach out to us on their behalf. I'm also we also have an email platform through our website. There's a number, it's a complicated thing in general when you're talking about multiple languages besides Spanish, Portuguese, and English. Having them all available at the beginning of a menu is just really complicated. There has to be some way for them to know that they can enter something to be pushed into that category. And that part in itself is challenging. So that's a work in progress. I'm expecting that to be modified within the next couple of weeks, but at this point, I would have them use 4 when they call in. That'll get them the English line. They will have to wait for somebody to answer the phone. So if they can make it through the menu at all to be able to use the option to get a call back, that would be preferable. But if they do hold the line open, eventually somebody would answer the phone. And yeah.
If somebody reaches you through the online option, does that mean that they get responded back to through somebody emailing them back, for example, or are they getting a call back?
If they left the phone number, they would get a call back. And if you're a caseworker and you're working with somebody that speaks another language, absolutely, you're welcome to email us that way through our website. It'll get assigned to somebody, and then actually they'll probably get an interpreter service on the line before they call the individual back.
Okay. Thanks very much, Lesley. I think in the interest of time, we should probably move on so that Gordon can help walk us through some of the existing resources that are out there for helpers to be able to help the folks that they're working with.
Hi, everybody. Gordon Shaw here from Community Legal Aid, and I'm tasked with sort of just giving you a quick summary of the resources. Many of these have been mentioned in the earlier by the earlier speakers, but I should also just mention that I am having unstable internet connection. So if I freeze, I apologize in advance, and I'm going to ask my co-presenters to rescue me and jump in. But what I'm going to do is I am going to show you a few of these resources, and I think it helps sometimes to just visualize what these resources look like. And key among these, switching to my screen, sorry, is this Massachusetts Legal Resource Finder, which is, well, actually, I feel a little guilty showing you this page because this site is about to go through a facelift, and probably within the next month, the appearance of the site and some of it is going to change in a much friendlier format, but the functionality will remain the same, and the URL address will also remain the same. But why is this site important? This is what we call in legal aid our legal access portal. It provides you both with referrals to legal aid programs based on an index of somewhere close to 600 legal issues. So let me just show you quickly just how that would look. If you look here, you've got a list of sort of big topic areas for finding help on a wide range of legal issues. There are 13 subject areas here. But if you were to go through any of these, it takes you through a series of questions and issue trees that helps you identify the specific legal help that may be out there for you. So it includes referrals to legal aid programs, but it also will include referrals to things that are help you, but don't necessarily involve legal aid, and includes links also to pages on trusted legal help websites like Mass Legal Help, like the state's website, and like Mass Courts as well, or the court's website. But for most folks, you're mostly interested in how do I find my legal aid program that assists me? And so one way would be to go through an issue here and just go through the complete interview, and it will then generate a list of resources for you. And among those will be the legal aid program that's in your community. But a shortcut would be to just go to this link here, which is the legal aid finder. If you happen to know that you're looking for a program such as, Greater Boston Legal Services, or you can quickly just come to this list. Let me just find one here. Well, actually, let me go to Community Legal Aid. That's my program. And it would give you information on how to apply for services. Includes things like the hours in which program is open for intake, the phone number for intake, and also if the program has a online application, you can link directly to that as well. But this doesn't answer, I think, the question that's hovering over this entire presentation, and it's clear from a lot of the questions in the chat. If I apply for legal aid, will there be a lawyer showing up for me in court? Will there be a lawyer who will be there with me when I show up for court? And I want to answer that slightly differently by changing sort of the way to think about what legal aid offers in terms of help. We are at the moment committed to trying to talk to everybody who has an eviction case, whether they've received a 14-day notice to quit or all the way up to having been served with a levy or notice of a scheduled eviction. We can provide you with an assessment of your case. We can provide you with guidance and hopefully put you on the right path in terms of how to resolve your case. That could include referring you back to financial resources or other kinds of help that's in the community. But certainly one of the doors that could lead to is actually getting an attorney who will actually appear for you in case. It's always been challenging for legal aid to serve the community that we've been charged with here in Massachusetts. I think it's not news to you that we do not have enough resources to give everybody a lawyer in Massachusetts, much less for an eviction case. However, the good news is, and there's been mention of this already, that there is an infusion of some new money coming into the legal aid system to hire up to provide increased support and help for people facing eviction in Massachusetts. It's been referred to as the COVID Eviction Defense Program. I'm hearing numbers that anywhere from, it'll lead to the additional hiring of up to 70 new advocates within our general legal services family here in Massachusetts. Some of those hires will be lawyers, but some of those are going to be case managers. Some of those folks are going to be providing intake support as well. That is in the works. And the plan as of today, and what we're in, is that we expect to have this staffed up by mid-December, certainly by the end of the year. But the main message I want to give to the community support people is that, yes, it's really important that you get your people to apply for legal aid. We are, all of the key legal aid programs do have an online mechanism to apply for services. So it shouldn't be a question of sitting on hold. If you have access to the internet, you should be able to apply for services. But if you don't have that, a lot of the intake systems for the key legal aid programs have adapted their intake systems during this age of COVID. A lot of programs have gone to remote intake, and it involves a lot of people leaving messages and getting callbacks. I can speak for my own program, which is Community Legal Aid, which serves Central and Western Massachusetts. We have gone to a complete callback system. We are returning everybody's call, if not the same day, within the next day. And of course, we do have an online platform through our website by which you can apply for services. So I know we wanted to save a few minutes at the end to answer some last minute questions, but I did just want to show you a couple more important sites. So Mass Legal Help, hopefully folks know this site already. It's an important website to bookmark if you haven't done so, because it is sort of the key legal help website providing lots of information. If you just scan across the top here, you can see the topic areas. But what I'm showing you is this special page that we created to basically give you the most important pieces of information and legal information that involves the coronavirus and COVID-19. I'm just going to scroll down slowly for you to get a taste of what's on here. So there's lots of information here around a lot of different legal areas, not just housing, but all sorts of things. And of course, like, you know, the web is this great, you know, connectedness that allows you to dig deeper in if you want to explore a topic further. In addition to that, we have the housing specific web page, and I just want to show you how it's organized so you get a taste of why you might want to go here. And even within there, you can focus right in on evictions. And mention was made of this guided interview that helps folks complete an answer and discovery and jury demand on their own. This is sort of the launch page that you can also access through Mass Legal Help. You scroll down before you start what you need to know, and then I'm ready to start my answer, and you just click this link here. And again, it's a guided interview. It's sort of like TurboTax for legal documents, where it produces the legal document at the end after you answered a series of questions. In addition, I just wanted to, you know, I think if you're looking for how to access rental assistance, this is the state's launch page, information page on how to get to RAFT and other resources. And I'm just going to slowly scroll down so you get a taste of what's here. It also includes information for landlords. I should also mention that I know that there's been some questions in the chat about help for landlords. This new money that's coming in to support eviction defense, there is going to be some money set aside, and particularly pro bono help is being developed to support landlords that qualify for assistance. And that definition of a landlord that would qualify for assistance is an owner-occupied landlord who is low income in a unit in a house which has 3 or fewer units. So there will be resources to help those landlords as well. And then what else do I want to show you? Because I'm mindful of the time. So if folks are interested in getting a little bit more information about the entire eviction diversion initiative, this is the new Baker money that was passed just a few weeks ago, you can get into it in detail here as well. Again, the links to a lot of things I've already shown you, but that's the nature of the web, right? 211 has a website, but I think the messaging from Lesley was that you should call, but you can also submit something online as well. This is the launch page. Oh, and then finally, a site that I don't think is as well known as some of the others I've just shown you. This is a website where volunteer lawyers will answer your question. You post a question, and through the website, lawyers have signed up to answer questions within their specialty. And so you can use this if you're working with a tenant or just anyone who has a legal question. You can post a question here, and it operates sort of like a chat. So it's just, there's something you might want to bookmark in your important websites, and this is something which can be used because legal aid is not equipped to run as a hotline. That's something we do not do. We do not have the ability to just answer general questions, and so this is an alternative way that you can get questions answered as well. So with that, I think that we have, what do we have? Well, we're just at 11:30. So what do we say, panelists? Do we want to continue to try to take 1 or 2 more questions? Jennifer, you've been monitoring. Do we have time for that?
I mean, if the panelists are willing to stick around, there's like 3 main questions that I think came up a lot that we might want to try to touch on if we can. The first is when it comes to RAFT, if somebody has already, say, applied, gotten the $4,000, are they able to go back and reapply again to get more money up to that $10,000 limit? Does anybody know the answer to that question?
Yes, they can. If their housing hardship is COVID related, then they could potentially be eligible for additional funds through the RAFT expansion.
Okay. The other question, there were a lot of questions that came up that were submitted early about rent sharing. And I'm just wondering if somebody could maybe touch on how evictions impact households where residents are splitting rent for one particular unit.
So I'm happy to tackle that question. So generally speaking, all tenants are all liable for all of the rent. So you can't evict one tenant and not evict the other tenants. So if one tenant is not able to pay the rent, then all tenants can be subject to eviction within a rental unit. So there's, as far as the eviction is concerned, there isn't a separation between the tenants, regardless of how they pay the rent. The question of whether somebody is a tenant in a situation where, let's say, one tenant has rented a unit and then is subletting, even informally, to other tenants, those subtenants would still need to be evicted. They still are tenants. They are tenants of the tenant holding under the landlord. So they still have the rights of tenants.
Thanks, Laura. Lastly, there's a few of the cities around us have their own local moratoriums on evictions. Can you talk about how those may be able to help some tenants?
Yeah, that's a tricky one. It's true that there are eviction moratoriums in Cambridge and Somerville. I don't know, we don't know yet how they're going to be applied or followed by the courts. So tenants should definitely bring it up that they're under those eviction moratoriums, and they should definitely reference that they're getting evicted in despite of it, and leave that for the judge to decide. But I think we don't know as lawyers how those are going to be effective and how they're going to be applied.
Thanks, Zoe. And maybe this would be a good place to end. Laura, would you like to tell everybody about the training series that you are planning to bring us to the next step?
Absolutely. So Legal Aid is going to be holding a 4-part training series. The first training will be a detailed explanation of summary process or eviction process, with the goal of helping advocates identify the basic stages of an eviction. So what is a notice to quit? What is a summons? And to be able to advise their clients on kind of what the process is going to look like. The second training will focus on tools for tenants. So it will run through the MAID answer and discovery system. It will run through Mass Legal Help and the Mass Legal Resource Finder. The third training will be a training on RAFT and other rental assistance. That training will be a rebroadcast of a recording that DHCD is going to do on those programs. And then it will also contain some localized information on rental programs that cities and towns are running. And then the final training will be a more nuts and bolts training on what you as advocates can do to assist your clients in getting through the eviction process. So how best to access legal aid, what you should be doing as far as getting the CDC declaration filled out, and we'll run through how to do that, as well as how to help advocate for your clients if they need an alternative to a Zoom hearing or they need an interpreter, things like that. So the way that it's working is each legal aid office is going to rebroadcast these recordings to be able to provide localized information to you. So I would say keep an eye out for communications from your local legal aid office on when they'll be doing that. Additionally, the recordings will also be available on Mass Legal Help. The first training is going to be aired tomorrow, and that's going to be aired by my program, the Justice Center of Southeast Massachusetts, and it's going to be targeted to our communities in the Brockton area, but they will thereafter be rebroadcast around the state.
Great, thank you so much, Laura. Is there anything that any of the panelists wanted to get in before we sign off?
I did just want to flag one thing that was raised, a question that I think is going to be applicable to everybody. So I just wanted to highlight that for those cases that were paused by the moratorium, if they were paused at the stage that an execution was already issued, or were paused where there was an agreement where the landlord simply had to ask for an execution, there wasn't a further hearing needed, What the courts have said is that they are going to be, on the request of the landlord, sending out new executions. So there won't be a further hearing, but my understanding is the courts will be giving out new executions. So I just wanted to flag that because timing wise, you know, we are likely going to be seeing people getting 48-hour notices, the notice just before somebody is physically moved out, fairly quickly. And that in those cases, if there is a loss of income or increased medical expenses and somebody is eligible for under the CDC moratorium, they should quickly fill out that declaration and give it to their landlord because it still could stop the physical move out.
Laura, sorry, Gordon, go ahead.
Laura, someone was asking if we will publish the dates for those events, and I think this group that's assembled here today, we have your emails that we will be sending out additional information about additional trainings. If this is a community, we want to remain connected. I should also just acknowledge that this forum was sponsored by the Massachusetts Access to Justice Commission as well. I want to give them their 2 cents in this as well.
I think that's a wrap. Thank you so much, everybody, for sticking on for some extra time. And we really appreciate the work that you're doing out in the community because we know that many of you are also on the really front lines of this. So thank you for your work. And we look forward to talking with you all again soon.